Welcome to the Wednesday edition of Anglican Unscripted. This is episode 108, and you're watching two guys with the midweek blues. I'm Kevin Carlson.
And I'm George Conger. Today's July 23rd, 2014.
Okay, it's Wednesday and we're going to have legal talk. Now, a lot of people have been paying attention to the Episcopal Church and lawsuits for about the last 8-10 years because they want to protect what they consider their property. And it's gone to different levels of the court, from appeals courts to Supreme Courts to your local judge and set of lawyers. We're now in the Diocese of South Carolina. We're seeing a little different strategy with a lot different outcome. And I thought I'd bring Allan here to talk about this. Once again, via the magic of Skype, I get to talk to my favorite Canon lawyer all the way across the sea. South Carolina is different because, first of all, Marc Lowrance got to sue Tech first.
Correct. That was a very good strategic move on his part. He was prepared for what he knew what Episcopal Church was going to do. As soon as they moved against him with disciplinary charges, he knew that he had 60 to 90 days to get his diocese in order and get them into court. And so they filed their suit. He was, I think, notified in October that he would be inhibited. October of 2012 or 11, maybe it was 2012, and January 2013 he was in court. And that was also, he got into court before the Rump Diocese could reorganize and take his name. They'd already, of course, started using his name and the seal on their website and sent out emails to make it look as though it was coming from his official headquarters. So he had a ready-made case to go into court in January saying, issue a preliminary injunction, please, to stop these people from using the diocesan sign and trademarks. And initially, that's all he had to sue for.
The secret is the Episcopal Church wants to take you to court, but they don't want to go to trial.
Well, they don't want to have their case tested in trial. They'd much rather have their theories blow the judge over in just one-on-one with the motion for summary judgment, and never have to have the proof put on to show that what they mean, that the facts are as they say they are. We're hierarchical, for example. We're a three-tiered church. Well, they can point to decisions all over the country that say that, but it's never been litigated. They've never really had to show it. And that's what's going on here, where Marc Lowrance is putting them all to the test and making them say, prove it.
Well, I take issue with some of their witnesses. I don't know if they've hired the wrong people, but under no certain terms should you ever admit that the person suing you is correct. I just say, I forgot, I don't know, I'm having a stroke, but don't say, right. Yes, of course, we're not hierarchical.
Yeah, to give them credit, they didn't quite go that far, yeah. But what happened was they were devastated on cross-examination, and if you remember the right to confront your witness at trial, it's a fundamental right that goes back to the Magna Carta. And in our jury system, when we have a trial of the fact, and in this case just to a judge, it's the same, we believe that the truth emerges from the clash of the opposite sides. So that means that you get to cross-examine the witnesses who testify against you. The purpose of a good cross-examination is to test how firm they are in their beliefs about the facts or the opinions that they offer. And in this case, they put on a pretty good opinion witness who was an expert in South Carolina nonprofit law. In fact, he wrote the statute. But Professor McWilliams, he went a little bit too far with his opinions, and in cross-examination, Henrietta Golding and Allan Runyon, the two main attorneys for Marc Lowrance's diocese, were able to poke some big wide holes in those opinions and get him to concede that, well, there's really nothing in the Episcopal Church governing documents, for example, that prevents a diocese from amending its own constitution so as to no longer be eligible to be a member of the Episcopal Church. And that's what happened in South Carolina. And so he all but, as I say, gave the case away when he effectively conceded that yes, they have the power to amend their documents under South Carolina law. After all, that was what the Supreme Court of South Carolina held in the All Saints Waccamaw case. And so this whole lawsuit has to be evaluated against the backdrop of that huge Mount Fuji in South Carolina, namely the All Saints Waccamaw case.
Well,
it's handed down in 2009.
A church has the right of association. But this whole world's falling apart. We give corporations the right to religion, and now we're giving churches the right to association. Now, I'm watching pretty closely here. It seems that the Episcopal Church is going to trial, but they're always going to trial for an appeals court. They're not doing this current trial. They're looking for the next trial.
Again, in an appeals court, they can make just a straight legal arguments like, look at all these other courts that have decided we're hierarchical, and don't mind all this muddy evidence down below that shows that it's really not quite true in this regard and not quite true in that regard. Now, overall, all the courts have decided we're hierarchical, so therefore you have to defer to us. And that argument is starting to lose force with the courts of appeal in all the diocesan cases. It didn't buy, the Texas Supreme Court didn't buy it. The Illinois trial judge didn't buy it, and now it's probably not too long before we find out how the Illinois Court of Appeal reacts, but from all indications that happened at the oral argument there, they're going to affirm the trial judge and hold also that there's nothing to prevent a diocese from leaving. There have only been 2 courts in the United States so far that have bought this argument, hook, line, and sinker. One was a trial judge in Pittsburgh, and the other is a trial judge in Fresno that we're dealing with now. And in both cases, they kind of just simply surrendered and said, whatever you say, Episcopal Church, just go ahead, take all the property. We don't, I'm not going to deal with it.
Well,
and so it has to go up on appeals then to correct it, and that's what the problem's been.
For a long time, it has been standard practice not to interpret religion canon laws.
Well, there's a canon in the Episcopal Church's own canons that says, member of the clergy shall not go into a civil court for the purpose of getting the canons interpreted. Well, what has the Episcopal Church been doing all these 75 lawsuits? I mean, this is part of the problem. The canons don't mean a thing to the people that rule the Episcopal Church. They're just tools to get people out of the church, to unseat people they don't like, and to make things generally punitive and malicious for individual parishes that dare to stand up for their rights. I mean, it is so offensive to me as a lawyer to see how they disregard their own canons and pretend as though they can do anything they want just because who they are. It's just a constant, I never tire. This is what fires up other people like me for battling them and opposing this, because this is just not right. It is not right.
And sadly, I mean, we've gone beyond the point where anybody in the Episcopal Church will hold the bishops accountable for this, or the clergy, or the presiding bishop. I mean, that time has come and passed. I think it was 6 years ago or 5 years ago, there was a chance that 3 of the bishops would have brought charges against the presiding bishop. That's done.
And now we're seeing it everywhere in the church. The lawlessness is spreading to all levels. For example, the dioceses that regularly allow communion for the unbaptized. There's a canon against that. They're supposed to prosecute people who allow unbaptized people to have communion. They haven't done that. They've never done that.
They've never done that,
Yeah, and there's a canon also that, and the rubrics of the Book of Common Prayer, which trump the canons, say that marriage is between a man and a woman. Well, so far, at least as my count, 6 or 7 bishops of the church have conducted marriage ceremonies for same-sex couples. Again, no consequences.
In fact, one has been married, now divorced. Yeah, I mean, it's just one of those things that what's the point of Scripture if you're not going to, if it's included but not followed? What's the point of your canons if they're included but not followed?
Right. It is an abysmal picture, and it's the picture of a church in decay and decline. And until it gets its house in order and reorganizes and has respect for both Scripture and its own canon law, it can't really be called a church.
So we found out what gets Allan's feathers up.
Right.
It's the Episcopal Church not following their own canons. Allan, I want to thank you for your time this week, and it's going to be interesting again as we talk about South Carolina and hopefully a huge victory next week.
We'll see how this results, yeah.